Hello, everyone. My name is Julia, and I'm joined today by my colleague, Alan. We're both attorneys with the Women's Law Project at the National Network to End Domestic Violence. Today, on this online information clinic, we'll be having a conversation about how to navigate some of the most common challenges in restraining order cases. In the description of this video, you'll also be able to find the links to slides and materials in both English and Spanish if you need them. And before we get started with our conversation, I did want to tell you a little bit about myself. Again, my name is Julia, and I've been with the Women's Law Project for about 5.5 years, but prior to that, I represented survivors of domestic violence in restraining order cases and other family law cases. Alan, would you mind also telling us a little bit about yourself?
Yeah. Hi again, everyone. This is Alan. As you might remember from the past videos, I've been with Women's Law for 2.5 years or so. And before that, I worked in private practice and with a legal aid organization. And in that, I've represented survivors in protection order cases, in custody cases, in divorces, and landlord-tenant cases, and a variety of other areas of law.
Thanks, Alan. Can you start us off by talking about something that you've seen or experienced that has been difficult for a client that you've worked with or perhaps talked to over the email hotline?
Well, Julia, when I practiced, I was in New York, and I was right on the border of Pennsylvania. And so we often had someone who lived in New York where the abuser lived in Pennsylvania. And so we had to try to file a protection order. And it can be really challenging when the abuser lives in a different state from the person that they're abusing. So in order for a judge to issue a protection order or a restraining order over someone in a different state, they have to have power over that person. And that goes actually for any kind of protection order. They have to have jurisdiction over the abuser in order to issue that protection order. This is what's known as personal jurisdiction. So if a judge doesn't have personal jurisdiction, then they can't issue an order that has any sort of meaning or control over that person. There are certain ways that a judge can get personal jurisdiction over an abuser. So obviously, if the abuser lives in the state, then they would have personal jurisdiction. That's not what we're talking about here necessarily. If the person lives in another state, then the judge can still have personal jurisdiction or power over the abuser if the cause of action occurred in the state where the case is being filed. The cause of action is the reason why you're filing the petition. So for example, if you were stalked, and the stalking occurred in your state, then the cause of action arguably occurred in your state. If there was a physical assault or some other sort of criminal action that occurred in your state, then most likely the judge is going to have authority or jurisdiction over the person who did that to you. So the cause of action occurred in that state. Another way that a judge can have jurisdiction over a person from another state would be if they were personally served with the court papers in the state where you're trying to get jurisdiction. So for example, if you live in California and the abuser is in Nevada, if the abuser is in California and you serve them with the papers for the court appearance and the order, temporary order if it was issued, then the judge can exercise personal jurisdiction over that out-of-state abuser. Another way would be if the abuser or the defendant consents to jurisdiction. This happens oftentimes without even realizing it. If a person appears at court and they don't contest the jurisdiction or object to the jurisdiction, then it's oftentimes deemed to have been waived, meaning they can no longer raise that argument in the future. And then the judge would have personal jurisdiction to carry on with the case. The last way gets a little bit more complicated, but if the defendant has some kind of substantial connection to the state, so if they own a business that they operate in the state, or they work or they're regularly in the state for business or for travel, then it's possible that the judge could have jurisdiction over them based on the substantial connections to the state. So those are some of the ways that a person can get jurisdiction, as you can see on the slide here. And then once the person has personal jurisdiction over the abuser, then they can grant the restraining order if the victim otherwise qualifies for one. So that's one of the issues that I've kind of experienced in my practice, Julia. Has there been anything that you've noticed that you think people would benefit from hearing about?
Yeah, definitely. And before we move on, I wanted to mention that I practiced in Washington, D.C., which is close to Maryland and Virginia. So sometimes we would have a similar issue, Alan, that what you just talked about. And since a lot of abuse happens over technology, I think it's worth mentioning that, if you are in one state and the abuser is in another state and perhaps sending you messages, harassing you through email or through text messages, and you're receiving those in the state where you live, you can perhaps make the argument that the abuse is happening in your state. I just wanted to mention that since that was something that I saw come up a lot.
No, absolutely.
And another issue that I would see come up is when a victim files a petition for a restraining order and they go to court and perhaps they did not include an incident on their petition that they would like to testify about. So for the most part, when you're filing your petition for a restraining order, you're going to want to include all of the incidents that you would like to testify about if the case goes forward to trial or for a hearing. In some states, the judge might only allow testimony about incidents that are actually included in the petition. This is going to vary by state, and it could even vary by judge. So you could be in the same courthouse, and one judge in one courtroom will allow a person to testify about other incidents because they want to know about the context of the relationship. But another judge in the next courtroom might say that that testimony about those incidents isn't allowed. So the reason, for the most part, that this happens, that the judge will not allow testimony about an incident that's not on the petition, is for fairness to the other party. For the most part, the abuser has a right to know what accusations are being brought against them so that they can adequately prepare for court and so that they can know what's being claimed that they did. So in a situation where the judge won't let the victim testify about an incident that's not in the petition, but perhaps they really do want to testify because they think it's important, the victim could consider amending their petition before the actual trial. The timing of when to amend the petition is going to depend on the state and on the specific situation. But in some states, the petition needs to be amended in writing before the trial date, and the abuser needs to be served with that new petition with all of the incidents. In some states, a judge might actually let you amend your petition orally right before the hearing. So it's really going to depend. If you're in a situation where you didn't include all the incidents on your petition that you would like to file or testify about, you'll want to check with a lawyer or maybe with the court clerk about how to go about adding those incidents so that you can make sure that they can be included at a hearing. If there's a situation where maybe you can't amend the petition, if it's not an option in your state, if the judge won't allow it, the victim can actually just go ahead and try to testify about those other incidents and see if the judge will allow it. If the other party doesn't object, or if the other party's attorney doesn't object, or if the judge says, sure, I'll hear it, then the judge might go ahead and consider that testimony, even if it's not on the petition. So it's worth a try if you aren't able to amend your petition. Alan, is there anything else that you've seen come up that you think is worth mentioning today?
Julia, I had many clients who were, I'd say, clearly experiencing abuse. So they would, whether it was manipulation, or if it was name calling, following them around, telling them who they could or couldn't hang out with, throwing things, financial abuse, restricting their access to checking accounts, etc. There was abuse happening, but there was no physical abuse per se. And so they would, would want to try to file a restraining order to try to get some relief from what was happening to them. And unfortunately, in many places, emotional abuse is not listed as a legal ground for a restraining order. So there are statutes in every state, which you can find on our womenslaw.org page, the information that describes what the legal definition of domestic violence is in your state for the purpose of qualifying for a restraining order. We've had some examples here. Let me put a few on the screen so you can take a look at what I'm talking about. We had one here from a California victim who's talking about stopping her ex from emotional abuse. She would like to get a restraining order against him. She can't leave her house, but he's sneaked into her home and he's taken her jewelry and other important legal bank papers. Please help. That's a pretty serious allegation. No one wants someone coming into their home. That's definitely a violation of your personal space, and I would consider that abuse. So we took a look at the California definition of domestic violence, which includes destroying personal property and disturbing your peace. So when you're drafting up your petition, you want to keep those in mind, because some of the incidents that she's complaining about here, that she's talking about, may qualify under these other forms of abuse, destroying your personal property and disturbing your peace. So it's all about how you phrase it. If you say it's emotional abuse, then a judge may or may not grant you the order. But if you can frame it as destroying your personal property or disturbing your peace or something else that's in your specific state statute, then the judge may have the ability to issue you that order. I'm going to change the slides. We've got another one here from a person in Utah. She was saying that her ex is emotionally and verbally abusive. He's only thrown something at me once. I've seen protective orders, but it seems like that is just for physical abuse. Is there anything I can do to protect myself? And so we, again, took a look at the statute in Utah, and their definition of domestic violence includes causes or tries to cause you physical harm or makes you afraid that you will be physically harmed. When you're throwing an item at somebody, whether it's a stone or a pen or, who knows what it is, but, that's potential for being physically harmed. It's an action that might cause or try to cause you physical harm, or at least makes you afraid that you'll be physically harmed. So in that instance, the person may be able to file for a protection order. And these definitions, especially this one, the threatens to or does some action that may cause you or makes you afraid that physical harm will be caused, you find that in quite a few states. I wouldn't say every state. Some states actually include an even broader definition, but that one I think we see quite a bit.
Yeah, Alan, and I've seen this issue come up on the email hotline quite a bit as well. So I wanted to talk about one that I saw. So I'll go ahead and share this next slide. And this one's from a victim in Missouri who writes, "My mother is emotionally abused by my fundamentalist father. He tells her and her kids what to eat, drink, wear, as well as how to talk, act, and even think. He tells them they will go to hell if they don't do as he says." So this might be classified as emotional abuse to this person writing in. And you would want to take a look at what Missouri's legal definition of domestic violence is to see how it should be framed in the petition. So when you do take a look at the legal definition, it includes both coercion and harassment. So coercion is using force or a threat of force to make you do something or to stop you from doing something. And harassment is committing acts, more than one usually, that causes you or your child alarm or substantial emotional distress and serves no legitimate purpose. So those definitions are going to be really important to look at when you're framing the abuse in this situation to make sure that it actually qualifies. The victim in this situation may want to see if the abuse that they're experiencing actually falls under one of these legally accepted definitions of domestic violence. And again, this is going to be really dependent on the state and on the certain situation. So if a victim is ever in this situation, they may want to talk to a lawyer about what the exact legal definition of abuse is and how to best frame their petition so that it qualifies for an order in their state. And is there anything else that you wanted to chat about today, Alan?
I think we've covered quite a bit on this one, Julia, and I know it's a lot of information, everyone. So if you do have more questions, you can find more information on womenslaw.org. We have state-by-state information in plain language, written in plain language. Also, we have a Women's Law email hotline. So if you have more questions, feel free to reach out to us on the hotline. It's an anonymous and confidential way to ask legal questions that are related to domestic violence, sexual assault, or stalking, and that's in Spanish or English. It's staffed by attorneys, including us here on the Women's Law team. So it may be myself or Julia or our other Women's Law team members who respond to you. But don't be afraid to reach out to us if you have more questions. This could be complicated and it's very important stuff. So please don't be afraid to reach out. So I want to say thanks for everyone for joining us on this online information clinic series. And I wish you all the best.
Yeah, thanks for joining me today, Alan. Bye, everyone.